Morning.
Good morning, Judge.
Good morning, Judge.
I'm ready to start when you are.
My lady, might I ask for a 2-minute delay? Our electricity has just went off. We're waiting for the backup system to kick in. It will do so in a minute or so.
Okay, that's fine. We'll just be in the background. Just come on when you're ready to proceed.
Thank
The
you.
matter will stand down. Thank you. Thank you. We may proceed.
Thank you, my lady. I'll just place the matter on record. As the court pleases, my lady, this is a matter between the Special Investigating Unit and one other versus Mr. Jacob Basley, Hlatshwayo, and 3 others, case number GP20 of 2020, appearing in the Special Tribunal of South Africa before Madam Justice Modiba, 6 February 2023. My lady?
Thank you. Counsel may place themselves on record.
As the court pleases, my lady, my name is Lesego Mtsomoloisane. I appear for the first plaintiff together with my junior advocate, Paul Ferreira.
Thank you.
May it please you, my lady, I'm Manala M.E. I appear for the first defendant.
Thank you.
May it please the court, my lady, it's Rasakhala M for the 4th defendant.
Thank you. You may proceed, Ms. Mtsomoloisane.
As the court pleases, my lady, this matter has been enrolled for trial from today in this tribunal. We have since received, yesterday very late in the afternoon, we received some documents and application, interlocutory application filed by the first defendant.
Is it not proper to deal with the settlement first, Ms. Mtsomoloisane? Because I've been
as a
advised
court
that
pleases.
there's a settlement. I think it's proper to deal with that first, because that would determine what happens with the case against the first defendant.
Thank you. Thank you, my lady. Thank you, my lady. My lady, in that regard, the parties have in principle agreed on the terms of the settlement, except on one issue, which my learned colleague, Mr. Rasakhala, still wants to take up with his client. But we also need to address that issue, his concerns with our clients. If that is if we have to commence with that, my lady, then I will ask your lordship, your ladyship, for a short adjournment to afford the parties to deal with that specific aspect. We have in our possession a draft order which has been sent through to Mr. Rasakala for consideration.
Okay, so you need more time to deal with the settlement.
From the first plaintiff's perspective, the settlement agreement has been finalized. So we need more time
there isn't consensus on all the terms, right?
As a court pleases, my lady.
Okay. Now, Mr. Rasakala, do you want to come in at this point?
As the court pleases, my lady, it is indeed correct, my lady. We have in principle agreed. There's just one aspect that was included in the draft order. I have raised my concerns on the item that they have now included in the draft order. I need to take instructions. They also have a concern to, if they were to exclude that, the one item. So they have also need to consult with their clients, so forth. I think 30 minutes should suffice for that.
Okay, thank you. Ms. Monsumuloisane, in the event that these parties settle all the disputes between them in relation to this matter, what are the implications for your case against the first defendant? Before we stand down, I just need clarity regarding where this matter is going.
Thank you, my lady. My lady, as a court pleases, my lady. My lady, firstly, there is an application to compel, which is still pending before this tribunal. It was brought against both the first and the fourth defendants. Then the fourth defendant did file the witness statement. It is uploaded on case lines.
But that case
to date.
What I'm asking you to address, in the event that the case between the plaintiffs and the fourth defendant settles, obviously that interlocutory falls away. What I need you to address is the implication of that settlement in respect of the case against Mr. Hlatshwayo. Because he's not part of that settlement, right?
Indeed, my lady, he is not part of that settlement. Then what remains against Mr. Hlatshwayo will be in respect of claim 2, which is for payment of damages regarding the shortfall, the difference in the mass which never got to the end users. Your ladyship would have seen the particulars of claim.
So your case against Mr. Hlatshwayo is that there are PPE items that were not delivered,
which never got delivered. That is the case against Mr. Hlatshwayo, and that's what he says in paragraph 9 of the affidavit in support of the interlocutory application, which was uploaded yesterday, my lady.
Okay, Mr. Manala.
My lady, I thought my learned friend wanted to say something before. Okay, my lady, we are fine. Either way, we would be ready to proceed. And as we understand, there would be a fall-off of claim 1 against us. And what would then remain would be claim 2. And we are ready to proceed right away with claim 2.
Okay. Okay, the matter will stand down.
As a court pleases.
There are no interlocutories between these parties, right?
It's on the 3 dots. Which one?
Ms. Monsumuloisane, will you respond to this question, please?
My lady?
There are no interlocutories between these two parties.
My lady, as I understand the interlocutory application, My learned friend, Mr. Manala, is seeking a variation or a discharge. Actually,
No,
the
no,
discharge.
In the trial, apart from that new application, in the trial, there are no interlocutories between these parties.
There is a pending application to compel. We still do not have any witness statement from the first defendant.
And how do you intend proceeding with that?
My lady, the application has been uploaded. It was uploaded sometime way back, and it's ready to be argued. Perhaps Mr. And there is no answering affidavit. It appears that the application, as it stands, is unopposed.
Mr. Manala?
Sorry, pardon me, my lady. We were just dealing with a minor issue that arose as a result of the load shedding. My lady, as far as we are concerned, the outstanding interlocutory application appears at folder 008, and that seems to be an application against Black Dot. We are not taking part in that interlocutory application, and as far as we understand the proceedings, that's the only outstanding interlocutory application. And in so far as our application, we've presented the application as we understand the process of this court, that we would get directions as to how that application would be dealt with.
Okay, Ms. Monsu Moloisani.
Thank you, my lady.
I was asking about an interlocutory application between the parties who are not settling.
My lady, that application to compel was uploaded. It's not just, let me go to case lines, or can we just adjourn?
Okay,
and
let's adjourn. You'll address me about it when we resume.
As a court pleases, ma'am.
And then your attorney should indicate to Mpo by email where that application is located on case lines. It appears that the defendants are also not aware of it. Okay, the matter stands down. It's now quarter past 10. We'll stand down until 11.
As the court
pleases, my lady.
As the court pleases.
Thank you. Are you ready to start?
Okay, fine, bye. You don't have to, it's fine.
You are this.
Yeah.
Are we ready to start?
Lady, we
Ms. Melisani?
Thank you, my lady. We are ready to proceed.
Thank you. Thank you, my lady. We may proceed.
You. As a court pleases, my lady.
Yes, you may proceed.
Thank you, my lady. My lady, we have just verified from case lines that actually my this application to compel appears under the items 007. It's 007 -19. This is an application to compel. And it was uploaded to Placelines on the 10th of August 2022. Your Ladyship will remember that the matter was enrolled for trial from the 22nd of August. So 2022. And then on the 10th of August, that's when this application to compel was filed.
Did
And
you
the
ask
proof
for a
of-
date of hearing?
Pardon, my lady?
Did you ask for a date for the application to be heard? Because this application should have been long granted.
My lady, what happened was on that day when we were before court, this tribunal was informed that Mr. Hlatshwayo was ill and there was a doctor's
Answer, I'm
note.
asking a very direct question. Did you ask for a date of hearing for this application?
My understanding is that our instructing attorney did ask for that.
When?
My lady, it should have been shortly after the application was filed, and that was in lieu of the fact that the trial was due to commence on the 22nd of August 2022.
And then what happened?
And we were overtaken by events in that Mr. Hlatshwayo was reported to be ill.
And then what happened?
And subsequent that to my lady, I'm not.
They also postponed because he couldn't give them.
The plaintiff's the first defendant's legal team then requested applied for a postponement on the basis that they could not.
This is your application.
Indeed, my lady, we have always been conscious of the fact that Mr. Hlatshwayo was reported not to be well. We expected feedback from the first defendant's legal team, which we never received.
Subsequently, I held a case management meeting with the parties when I enrolled this matter for trial. Remember that meeting?
I do remember very well, my lady.
Okay.
But as the matter stands now, the application is still before your ladyship, and no answering affidavit has been filed to date. We are not, we have not been informed what the position of the first defendant is, whether they still intend filing any witness statements, whether they intend filing the answering affidavit, what is the position. But pertaining to the case against the fourth defendant, my lady, we have managed to reach an agreement on the issues that we could not agree on with the fourth defendant's counsel, Mr. Rasikhala, and we are in possession of the draft order.
Have you emailed it to Ms. Mashitisho?
It has been emailed to our instructing attorney.
Have you received it?
No, my lady, I have not received it yet.
Mr. Rasikhala?
As the court pleases, my lady, I've also not had sight of the revised draft order. I was checking my emails now. It's not there, but we have reached an agreement. I must just see what is the content of the draft order.
Okay, I also need to see it. Because until I accept it, then there's no agreement. It needs to be acceptable to the tribunal.
Indeed,
Ms.
so.
Munkumuloisan.
I'm with you. I'm with you, my lady.
Has the draft order been sent?
Yes, it has been sent. It has just been amended and sent through.
Is it just the draft order, or is there a settlement agreement?
No, my lady, unfortunately, we decided on using just the plain draft order. One of the parties who's authorized to sign the settlement agreement is not available. Hence, we have moved for a normal draft order. But we have discussed that at length, and the parties are in agreement.
Okay, I'll stand down for the draft order.
We'll just ensure that it's there. We'll just verify whether it has gone through, but it has been sent. As a court reasons, my lady.
We may proceed, Council. Ms. Muloisan, Mr. Rasekhala, Mr. Manala, are we back?
Thank you, Mpho. We are back.
Mr. Rasekhala,
I'm here, my lady.
Mr. Manala,
My lady, Mr. Mala just stepped out, but I've sent him a message to indicate that we are proceeding.
we'll just wait for Mr. Manala and then we may start, my lady. No, my lady, I was saying we are just waiting for Mr.
Oh,
Manala,
when he
then
comes
we may
back.
start. I will let you know when he's back. Yes, my lady. Thank you. Thank you. Ms. Muraisani, Mr. Rasikhala. Thank you. Thank you, my lady. You may proceed.
Thank you, my lady. We are indebted to you for the indulgence. My lady, just before the adjournment, your ladyship wanted to find out what was the position with the settlement, the draft order that we had agreed to and which we still wanted to finalize. The draft order has since been discussed and has been acceptable. It is acceptable to all the parties. And it has been uploaded on case lines. My learned friend, Mr. Rasikhala, should be in a position to confirm that he is satisfied with the contents thereof. As a court pleases.
Yes, I've received it. The SIU will know that I normally require an affidavit. There's a standard format. I don't even have to send them directives. They know what I require when there's a settlement. Because this settlement is very quiet. I don't know the basis on which it's reached. Black Dot is not accepting any liability. I don't know what facts have they admitted. I don't know on what basis you're settling. So I'm not here to simply rubber stamp that settlement agreement. So that's why I wanted to see the draft order. Otherwise I would have stood down, I would have just accepted that the parties have settled and then called for it later and then proceeded with the rest of the issues in the trial. But I needed to see it. And it's very clear from the application that Mr. Hlatshwayo brought over the weekend that settlement has a bearing not only on the interlocutory application, but on the remaining issues in the trial. So the basis for the settlement ought to be set out. The SIU knows the format. So at this point, I'm not making that draft order an order of court. I do require those affidavits. And I'm not sure if the rest of the issues should be proceeding until we have that affidavit. And the requirements of the affidavit may have implications on the terms of the settlement, because I see that Black Dot is not admitting any liability. So they've not admitted any facts. They're simply admitting that the contract was irregularly awarded and it may be set aside. But there's issues regarding exactly what was delivered, what was not delivered, which bears relevance for the rest of the trial. And I don't know why those issues are not being disclosed in terms of exactly what was agreed.
As the court pleases, my lady, we did not anticipate
Your
this,
attorney ought to have. Ms. Zondi is always before the tribunal. She's settled many matters. She knows we don't rubber stamp. We don't simply rubber stamp settlement agreements. You see, if they were settling for the full amount, maybe I could infer that they are admitting the full claim, but I don't know on what basis the settlement agreement is reached. This is not the SIU's money, it's public money. If you read Buffalo City, Constitutional Court has made it very clear that courts must properly apply their minds to settlement agreements. We don't just rubber stamp. And it's worse here. This settlement has a bearing on the rest of the issues in the trial. Okay, so I'm inclined to stand this matter down for the day. Let me hear the other parties.
As a court pleases, my lady, I was about to propose that, my lady. Thank you.
Mr. Rasukhala.
As the court pleases, my lady. My lady, you would have taken note of the fact that it's a full settlement, because they have claimed, it's claimed 3. They have claimed 860, if I'm not mistaken, from us.
It's 870. The settlement agreement says 7 something less VAT, which has been paid. So my reading, because if the amount settled is the actual amount being paid, it's not even necessary to say anything about VAT. Or it just needs to be made clear that you're settling for the full amount, but the amount that will be paid is so much because you're discounting the amount paid to the receiver. That should be very clear. But the facts, the facts on which the settlement agreement was reached must be set out in the affidavit that the SIU must submit.
Yeah, unfortunately, we have not had sight of the affidavits.
Because they've not prepared them. They know, the SIU knows that I don't simply rubber stamp draft orders. They must set out the basis on which they have settled. Remember, it's in the public interest, so it's not, this claim is not for a particular person in the SIU, it's in the public interest. So I must satisfy that the settlement serves the public interest. And to satisfy me, they must set out the basis on which the settlement was reached.
As the court pleases, my lady, we are agreeable then to have the matter stand down until tomorrow. That they provide us with the affidavits and we'll take it up with them.
Okay, Mr. Manala.
My lady, there's going to be a problem as we anticipate. Because if they are going to make out facts which are agreed upon between them as grounding their settlement, we're going to have a difficulty because, as we understand it, those facts are disputed and we intend to deal with them in evidence. So we had taken the posture of standing out of their negotiations and settlement on the basis that they would settle on a compromise without necessarily agreeing on those allegations which centrally are being attributed to Mr. Hlatshwayo. So I can anticipate that once they say these are the facts we agree upon, we are going to have a difficulty with that, because on those findings we would have a peculiar interest, because the facts would then touch on the conduct of Mr. Hlatshwayo. So it seems very likely that they would not be able to proceed on that basis.
Then the trial should be proceeding first.
We are ready to proceed.
You are really ready to proceed. Yes,
my lady, my lady, we could not hear what Mr. Manala was saying. Can your ladyship just repeat for
Mr.
our
Manala
benefit?
Mr. Manala, please repeat.
Mr. Manala, yes.
Yes, my lady, the point that we've made is that the allegations that are presented for the relief claimed in relation to the setting aside of the contract and the so-called overpayment in comparison with the prices of the National Treasury are the facts which we intend to dispute. Now, if they are going to present a settlement on the basis that they agree upon those facts, we would have a difficulty because the purported agreement would impact upon what would appear to be Mr. Hlatshwayo's conduct.
Okay, the claim against Mr. Hlatshwayo is claim 2, right?
Yes, 2 and 1 and 2.
Okay, claim 1.
Under claim 1, my lady, they claim in payment of 870,000.
Yes, but that quantum is being settled.
But there's a, pardon me,
The quantum in claim 1 is being settled by Black Dot.
I accept that.
Yes, and I'm told they're settling the full amount. The articulation will, as I've indicated, may have to be more clearer, but they're settling the full amount.
Yes.
Which means I don't see why there'd be any loss pursued against Mr. Hlatshwayo in respect of claim 1. If Black Dot settles that claim.
Well, practically that is the end of it. But
yes.
But our concern is this.
Yes.
Our concern is that, as your ladyship indicates, they must then set out the facts that are agreed upon that bring about a conclusion in relation to their settlement. And that fact would be, amongst others, that is the substantial fact. It would be that they agree that the amount for which the contract was awarded ought not have been that amount because the National Treasury Transversal Contract prescribed a lower amount, and that is what we dispute.
Mr. Okay, claim 1 is based on the cause of action for claim 1 is the loss that is occasioned by overpricing.
Yes.
Right?
That is so.
Claim 2 has nothing to do with overpricing. So if Black Dot settles the full claim, there's no loss arising from overpricing. That's the end of that matter. There is no loss. So claim 2 has nothing to do with overpricing. Claim 2, the cause of action for claim 2 relates to the amount of PPE items delivered.
Yes. There's no difficulty on that one.
So it's important to delineate these issues. As you yourself indicated earlier, what remains against your client is claim 2, not claim 1. And Monsu Moloisane agreed.
Lady, can I perhaps try make the point again this way?
Yes.
The impression that is being made, or that we take, is that they are compromising claim 1, this overpayment. Now, if your leadership requires them to set out the facts they agree upon as a basis for compromising claim 1, we have a difficulty because those facts would suggest Mr. Hlatshwayo awarded a contract at a higher price. That is where our difficulty is.
Is it your client's case that the contract was regularly awarded?
We're talking on the price, my lady.
No. Is it your client's case that the contract was regularly awarded?
We do not really wish to contest that area because we have no substantial interest in the outcome of that case. Whether that contract is reviewed or set aside, it has no bearing on our. So we don't intend to take issue with that part of the case.
So what is being settled is claim 1, right? I'm not sure what then happens to claim 3. And the course of action there is also not clear. But let's focus on your client's case, Mr. Mana. Let's claim 2, right? Your case against your client is claim 2.
Yes.
That remains. And the allegation there is that he acknowledged receipt in writing of 400,000 surgical masks,
Yes.
but only received less.
Yes.
And then there's an allegation. So the case against your client is that the department suffered a loss because he acknowledged receiving an amount of masks when he actually received less.
That is so.
And then the claim has been quantified on the basis of some amount which is stated there. The particulars of claim says it's a cost of 28 rands 75.
By 67,000.
Yes, yes. So I don't see the relevance of the excessive pricing issue there, because the issue is an X amount of masks were not received. The department paid an X amount per mask. Therefore, in relation to the masks that were not received, the amount paid should be paid back by Mr. Hlatshwayo because he has caused the department loss. So I don't see the relevance of pricing there.
My lady, we'll deal with that issue in evidence. I take your point. We'll deal with it in evidence.
Okay. Ms. Munsumuloisane.
Scott, please.
Yeah, I'm standing down the settlement until the end of the trial with until the issues with Mr. Hlatshwayo have been determined.
And my lady, while still on that, are we still expected to file answering papers in respect
of what?
In respect of the interlocutory application, or has that fallen away?
No, I believe they are persisting with it. So I'll give directives regarding that. That should not disturb the trial because the issues in the trial remain. So if you need to oppose it, I'll give directives.
Thank you. Thank you, my lady.
The trial is ready to start. Mr. Manala, do you agree?
My lady, we do agree that the trial should commence.
Yeah. Okay, so let me just issue directives regarding the interlocutory because it appears that the SIU would like to oppose it.
Yes, my lady, if we may make submissions, given the hour that we've already lost, the ladyship could, as usual, provide the parties with the written directives when it is ready.
Yeah, I normally don't impose dates by which parties should answer unless they suggest very unreasonable dates. So I'd like to hear from them regarding when they will answer. Ms. Munsumuloisane?
My lady, I think by the end of the week will be ideal for the first plaintiff.
Why are you taking so long? Is it because you're in court?
It's a short affidavit. We can even,
Yes.
make it available maybe by Wednesday.
Okay, and then reply, Mr. Manala.
My lady, we do not anticipate that we would have to reply because as we see it, those facts are common of us. And if needs be, we'll need a day after that, after the delivery of an answering affidavit to consider whether or not we need to reply. But as it is, we don't consider it.
Okay, so by Thursday, heads of argument by Friday. Is that?
We agree.
What about the application to come back?
Okay, Mpo, please note these directives. We're not going to give them to you in writing. Please note them, Mpo.
Will do, my lady. Thank you.
And then, how long is this trial that we are starting now?
This week.
It has been enrolled, my lady, for 5 days.
It's a smaller trial now. How long?
Indeed, my lady.
How many witnesses is the SIU calling?
Perhaps 2 days, 2 or 3 days, depending on. We have not received any witness statements from the first defendant, but we are. And at the last case management meeting, my lady, which was held on the 27th of October last year, it's on the matter appear, the minutes appear at case lines 0019, item 19. That's where we were informed that the first defendant was still not well and he was reported to be hospitalized.
Okay,
so we don't know.
How many witnesses are you calling?
No, we want to
with
know. We want to know, my lady, whether they intend calling witnesses, and if so, how many?
Monsu Moloisane, deal with your case. I'll move to them, then you can hear.
Thank you, my lady.
How many witnesses are you calling?
We intend calling about 3 witnesses.
Who are you calling?
Currently. We intend calling Mr. Choche.
Please spell it.
Detective CH, get the name. CHO CHE. The Chief Director, Supply Chain Management. And Miss Current, that's Mr. And Miss Current.
No, the Chief Director, Supply Chain is who?
Supply Chain Management at the department, second plaintiff's department.
Who's that?
Mr. Choche, Ore Okame Choche. ORE.
Okay, the second person?
Karen Della Ruby.
Miss Karen, KAREN. Della Review. It's quite the difficult surname, my lady.
Okay, the last person?
Detective Rexon Masinga.
And you have no difficulty with the tribunal receiving this evidence virtually? You have no difficulty?
I personally don't have any difficulty, my lady.
Okay, Mr. Manala?
It is even more convenient that we dispose of the matter virtually.
Virtually, okay. Are you calling any witnesses, Mr. Manala?
My lady, at this stage, we anticipate we're going to mount a request for absolution upon the conclusion of the case. And if we don't succeed there, we're going to provisionally leave it at the point of calling Mr. Hlatshwayo. And depending on how the evidence, the plaintiff's evidence pans out, we may decide to call other witnesses. But at this stage, we are wait for them to make out their case and take it forward.
You've not filed witness statements?
Yes, my lady. the ladyship would recall that there was a judicial management directive that we should file, and due to illness of Mr. Hlatshwayo, we were not able to even oppose the application to compare. And it seemed to us that the plaintiffs were no longer persisting with that. However, if we are to engage with that issue, our preliminary position is that we should attempt to persuade the court on the entitlement to remain silent, particularly when one considers the type of allegations that are made and the prospect that the evidence in these proceedings would be used in other proceedings, as there are already other proceedings pending against Mr. Hlatshwayo. So we would adopt a stance that seeks to remain silent and await for the SIU to complete their case.
Ms. Monsomoloisane?
My lady, I tried to indicate that we couldn't hear a lot of what Mr. Manala was
I saw
saying.
your hand, you were waving, so
Yeah.
I didn't know what you meant.
I wanted
to say something. Okay, Mr.
Yes,
Manala.
hence I raised the hand on the system to say Mr. Manala must please speak up or get closer to the computer.
Mr. Manala, are you able
We
to
did
zoom
not hear
in?
anything.
My lady,
Are you able to zoom in your camera?
I will try to zoom in the camera.
Are you able to zoom it more? To zoom it in more? It assists if we can lip read you. Yes, that's much better. Thank you. It's much better.
Yes. My lady, am I audible enough?
Ms. Monsomoloisane?
Yes, we could hear what you were asking, whether you are audible enough.
Right. My lady, in relation to the witness statement for the defendant, we ask that we present those witness statements after the conclusion of the plaintiff's case in answer to what is going to come. At this stage, we wish to exercise the right to remain silent, particularly taking into account the nature of allegations and the implications that may come from this allegation.
These are not criminal proceedings, so you can't talk of a right to remain silent here.
Well,
it's a Section 35 right. It doesn't apply here. You know the law. You know the law. It doesn't apply here.
My lady, the plaintiff has to start as the dominus litis, and the defendant has the option to put a version to those witnesses as the trial goes by or not to do so. And the defendant would have an election at the conclusion of the case to decide whether or not they would adduce evidence in rebuttal of the plaintiff's case. Now, we're saying once we put out a statement of witnesses at the outset, it compromises those options that we have along the line.
Mr. Manala, you should actually be seeking leave, because in terms of the tribunal rules, your client ought to have filed the statement. You were directed to file it.
Yes.
So you should be seeking leave to file it when you're suggesting you'd like to file it, so that Ms. Moloisane can deal with that.
I accept that. But what we had provisionally taken, and maybe we were wrong to do so, we had formed the view that since the interlocutory application was no longer proceeded, we took the view that they had abandoned the approach to request or insist on those statements.
Yeah, they didn't persist with it.
Yes.
They didn't persist with it, and they can't say it was filed.
Yes.
I mean, even last week, I dealt with Black Dots one, and they didn't raise this other interlocutory. So they didn't persist with it at this. Yeah, that's where things are at. Ms. Monsomoloisane, so you're seeking leave to only file it at the end of the plaintiff's case. Just know, if it occasions a postponement, there are cost implications, right? Because it was due when it was due. So you are facing that risk, that if it occasions a postponement, then there could be cost implications.
Lady, we should be able to present the witness statement in a matter of hours after the conclusion of the plaintiff's case.
Yeah, but the plaintiff has not prepared. The plaintiff has not consulted on the witness statement. So hence I'm warning you that if it does occasion a postponement, you would have caused that postponement.
My lady, we can assure you that the witness statement would mirror the approach that has been taken in the affidavits that have been filed, and it would also mirror the approach in the case. It shouldn't be something that comes as a surprise to the plaintiffs.
Ms. Nontsumolo-Isane?
As it pleases you, my lady. My lady, it's unfortunate that Mr. Manala has elected to conduct this the first defendant's case in this manner. Mr. Manala, on the 21st of August 2021, your ladyship will remember there was no
history. Ms. Nontsumolo-Isane,
but then
you tend to start very far. We know this history. The facts are very common cause. The issue is that you didn't persist with this application to compel. Hence, it has not been dealt with. Remember, there was a case management meeting that I called, and we were informed that Mr. Hlatshwayo had recovered. Hence, I enrolled the matter for trial. You still did not persist with your application. Even last week, when I was ready to deal with the Black Dot application, you didn't persist with that application. So we're sitting here, it has not been granted. So if, assuming if I grant the order now, when are they to comply?
My lady, Mr. Hlatshwayo is in attendance on this virtual platform. He is in attendance. There is no reason why he cannot depose to a witness statement or whether...
Ms. Nontsumolo-Isane, in the application, you said they should comply within how many days? 3, right?
Indeed, my lady. And they were supposed to have filed by the 21st of November 2021, but that is water under the bridge, as your ladyship has indicated.
So if I grant an order, if I grant your application that they comply within 3 days, what are the implications? Do we wait for them to comply? The trial should start. The trial should start. If you need to consult with, I've already dealt with those issues with Mr. Manal. If you are prejudiced in any way, you can argue for costs. The trial should start.
Are we commencing now or tomorrow, as your ladyship had indicated?
Why should we waste this day further? I think we should perhaps. What's your proposal? I think we should start.
My lady,
we can take the lunch break and then start.
My lady, with due respect, we did not anticipate this, as there was this interlocutory application, but we are in a position to proceed with all our witnesses being in attendance.
What are you saying? Are you ready to start after lunch?
Your ladyship indicated at the commencement of this, after the adjournment now, your ladyship, when we got back, your ladyship indicated that you are standing this matter down until tomorrow morning.
Are you ready to start after lunch, Ms. Nontsumolo-Isane? I stood the settlement down, right? I had stood the settlement down. I don't think we should waste the day because the trial is proceeding.
Indeed, my lady. As a court pleases.
So are you okay to start after lunch?
We are still of the view that tomorrow, in light of the developments that occurred, we will not waste any more time from tomorrow morning, even if we have to commence at 9.
What's outstanding now? Because we can just start if you are ready. Okay, let me hear Mr. Manala.
My lady, I have a difficulty with starting later, especially given that I'm going to require more days as we go by. So the sooner we start, the more we can utilize these days that are available. But whatever is convenient to the court, we submit to it.
Yeah, Ms. Monsumoloisane, is your first witness available to testify today?
Yes, Mr. Masinga is in attendance.
Is he your first witness?
He was not scheduled to be the first witness, but we can commence with him.
Okay, let's start after lunch.
And my lady, with regard to Black Dot, what is the ruling regarding Black Dot?
No, the settlement agreement stands down.
But regarding the evidence that is going to be adduced now, which are they part of the proceedings?
No, they are not part of the proceedings. The trial is only proceeding against Mr. Hlatshwayo.
But, my lady, perhaps we need to obtain instructions, as my understanding is that if we proceed with the trial, then we proceed with all the parties, as the draft order has not been accepted by the court, then we proceed against all the parties.
Ms. Monsumoloisane, you're complicating this thing. Don't complicate it.
May I make a submission as another
Yes.
submission, my lady?
Yes.
If we are not proceeding against Black Dot, as your ladyship has indicated, then it means evidence cannot be adduced. That I'm not quite sure what the implication of this is. As Black Dot has to be there to cross-examine the witnesses based on what?
No. The trial is proceeding on the basis that Black Dot and the plaintiffs are settling. So they are not part of the trial. It makes no difference. All I've done is I've stood that settlement process down. That's all I've done.
I mean, your ladyship's hands.
Mr. Rasekhala.
As the court pleases, my lady.
Do you have a difficulty with this approach?
We don't have a difficulty, more so because you clearly indicated that they are only proceeding in as far as claim 2 is concerned. So there is no need to leave evidence on claim 1 and claim 3.
There's no need for you to participate.
Yes.
Yes. Okay. So let's resume at, I don't know how long you want to take lunch for. It's almost 1 p.m.
Melody, might we ask after lunch, when would the court rise to adjourn for the day?
At 4.
Okay.
Yeah. So can we start at 2? I don't know how long you need for lunch, but an hour is what you're entitled to.
Melody, given the 2 hours, in fact, it's the 3 hours on the screen, we should perhaps consider an adjournment of about 30 minutes.
Okay. Ms. Monsumoloisane, 30 minutes? I'm fine with that.
Say 30 minutes. Is he saying 30 minutes? This,
yes.
30 minutes, my lady. Mr. Masinga is on the virtual platform as well. We need to take him through this. An hour is the normal lunchtime adjournment. Unfortunately, we are not even going to have that privilege of having lunch, because we have to proceed with preparation of the witness now.
Well, because he wasn't going to be your first witness.
He was not going to be the first witness.
But where's your first?
And he's got to attend to other issues.
Where is your first witness?
She is on sick leave, but we can ask her to attend on She has just had an eye operation. You can ask her to attend on the virtual platform.
Have you consulted with her? Are you ready to proceed with her?
I must
You
be
are
honest, my lady.
You are wavering. You are wavering.
We are not wavering, my lady. We have spoken to her,
Yes.
but consulting for the purpose of adducing evidence is another issue. But we have spoken to her before. Where
So-
she is sitting now, she's laboring under the impression that the matter has become settled in respect of Black Dot and is only proceeding in respect of the unaccounted 12,410.
That's the basis on which the trial is proceeding, Ms. Montsumoloisan.
Yes, we need to make her aware, my lady. We can quickly call her now to find out whether she is in a position to attend now.
Okay, I'll give you an hour. Okay, I'll give you an hour. So we'll resume at 2.
Thank you.
We adjourn for lunch until 2 p.m.
As the court pleases.
Good afternoon. Are we ready to proceed?
Good afternoon, Madam. On our side, we are ready.
Thank you. As Ms. Millicent has not logged in yet. Ms. Zandi, may we proceed? Thank you. Ms. Millicent, are we ready to proceed?
Let me quickly find out something from my instructing attorney. We just now, just 2 minutes.
Please indicate when you're ready to proceed.
Just me.
Thank you. My lady, none of the plaintiff counsel nor the attorney are here. They're saying that they're on load shedding, but they will try to reconnect shortly. So I'll let you know when they've rejoined.
Okay, thanks, Mpho.
Thank you.
Yes, ma'am, we are ready to proceed.
Thank you. Thank you, Mr. Manala. My lady, we may proceed.
Good afternoon.
Good afternoon, my lady.
Did you hold a pre-trial conference?
We couldn't hear, my lady.
Did you hold a pre-trial conference? I don't see the pre-trial minute in the bundle that was sent to me.
There was none, my lady.
Okay, we can proceed, and the pleadings are all over. So you will spend the rest of the afternoon in a pre-trial conference. Because just from going through the pleadings, I have difficulty determining what is in dispute, what is not in dispute. Mr. Manala, earlier on, when I asked whether you're disputing whether the contract was irregularly awarded, your answer was not clear. But you seem to have said you're not in a position to dispute that, but your plea vehemently disputes that the contract was irregularly awarded. And then there are issues not pleaded to. So as matters stand, it's going to be very difficult for me to conduct this trial because I won't know what's relevant, what's not relevant when witnesses are testifying. So spend the rest of the afternoon. You may even use this platform. I'll simply exit it. Spend the rest of that, or if you want to create your own link, just let Ms. Mashitisho know if you'd like her to shut down the link. But spend the rest of the day on a pre-trial conference so that it's very clear what are the common cause facts, what is being disputed, so that I'm able to conduct the trial in an efficient manner.
Thank you, my lady. But my lady, we do have other issues to raise. Our witnesses are sitting in Johannesburg. They do not have access to unlimited data. When I indicated to your ladyship that I did not have any issues in the trial being conducted virtually, I was not made aware of that predicament.
So would you like us to be in court tomorrow?
In court, my lady.
Okay, Mr. Manala, I'm fine with that. Mr. Manala?
Maybe the other convenient way, and that is because we are this side of town, with load shedding the traffic flow, we tend to lose more time driving to and fro, which time we could use to allocate extra hours in order to make up for the day that is lost today. So the witnesses that are in a struggle with connectivity, they could easily join counsel in counsel's chambers and they could be assisted there.
No.
Okay, we'll be in court.
Yes. If you get on the highway, once you are on there's no traffic lights on the highway. You get on the highway, once you get on the N12,
on time,
it's 2 or 3 traffic lights and you are at the Boyson's Magistrates Court.
Yes, the difficulty generally is getting onto the highway, especially from where I reside. There's about 20 sets of...
You wouldn't argue that before JP Ledwaba. You would not.
I would sleep closer to the courtroom.
You can do that. There's Ikotaba Hotel, actually not far from Boyson's Magistrates Court, a very nice hotel.
No,
you could go put up there tonight. So we'll meet tomorrow 10 a.m. Boyson's Magistrates Court.
My lady,
the minutes should be filed tonight. They should be filed tonight. So how long do you think you're going to take in this meeting? It's almost 2:30. 2 hours, 4:30. The minutes should be filed by 6:30.
My lady.
Yes.
That is not the only issue I intended raising. The other issue is based on the issue of the witness statements, based on what Mr. Manala submitted when your ladyship was inquiring from him as to when he, how long it would take him to make the witness statements available. Unless I did not hear him well, but my understanding was that he said it will take him about an hour to file those witness statements. Now,
that's not what he said.
Hence I said, unless if I did not hear him well, understand him well, or hear him well.
He sought leave to only file it at the end of the plaintiff's case in the event that he's not applying for absolution.
But, my lady, that is very prejudicial. We submit, my lady. Firstly, it is difficult to to adduce evidence without the witness that will be leading, having had the benefit of commenting on what Hlatshwayo has to say. That is the first defendant has to say. And Rule 19.6, capital B, is clear and unequivocal. Both parties have to file their witness statement, my lady.
You didn't pursue your application to compel, Ms. Monsumuloisan. You didn't pursue your application to compel. The trial is now about to start. You did not pursue that application.
My lady, at the pre-trial, at the case management meeting of the 27th of October, 2022, it was indicated that they would, the understanding was that they would revert to the first plaintiff's legal team as to when they would be in a position to file Mr. Hlatshwayo's witness statements. And that was based on the fact that they submitted, Mr. Manala submitted that he was unable to consult with the client and obtain further instructions.
Yes, the application was removed. The application was then removed from the roll. You've not pursued it further, Ms. Monsumuloisane. It was removed from the roll by agreement. You've not pursued it further. And now the trial is about to start. They will need to put a version to your client. If they don't put a version to your witnesses, then it means the witnesses' evidence is not disputed. Why are we wasting time on this issue when I've ruled on it? We've dealt with it this morning.
Well, the last one is about the issue of the draft order. I just want to place it on record, my lady, that the evidence with the black dot having been excused from the proceedings. Okay, I see Mr. Raskala is still in attendance. The evidence that is to be led in the absence of any finding that has been made or that your ladyship has made, the evidence is so intertwined, it's interrelated. The evidence on claim 1 and claim 2.
But you are settling the matter. It's not my problem. You are settling it. I've simply elected to deal with the settlement later. So if you are no longer settling, let Mr. Rasekhala know and proceed against both parties. It's not my election, because that problem would not go away. If I had made the settlement agreement in order, if I had made the draft order in order of the tribunal, you're not sitting in any different position. So I don't understand what this issue is.
Well, my lady,
you're only proceeding against one party, you're settling with the other. All I've done was to stand the settlement down. It changes nothing. That's the problem you created for yourself.
My understanding, my lady, was that you even referred to that specific statement where it says without admission of liability. Where now we have to adduce evidence based on just limited to claim to only.
I'm not limiting any evidence. Run your case. All I've been informed is that you are settling with the fourth defendant. I've stood that settlement down. So your case against the fourth defendant is not proceeding. Run your case against the first defendant. Obviously, the evidence must be relevant. And that's why I've directed you to hold a pretrial conference, because I don't know what is not in dispute. I don't know what's in dispute. Deal with all those issues in pretrial. Ms. Monsumuloisani, you've disappeared, so I don't know whether you're still online or whether you've come off.
I am online, my lady. Well, my instructions are that we raise these issues at the pre-trial conference that is about to be held. If we are not in agreement regarding the way forward in respect of the matter, then we will have to reconsider the draft order and decide whether to withdraw it or to stick to it.
Mr. Hlatshwayo.
As the court pleases, my lady.
Yes, you should be in this pre-trial meeting.
I will be.
Okay. It is in the interests of justice that I have decided to stand the draft order down, because I could foresee exactly the problem she's raising now, which she created for herself. It wasn't created by the tribunal. She created for herself. So all the parties, all the parties should be in a pre-trial, in the pre-trial conference.
As the court pleases, my lady.
As the court pleases, my lady.
Okay, we are adjourned for the day. We will resume tomorrow in Court 5 at the Boyson's Magistrates Court. And the minute of the pre-trial conference should be uploaded onto case lines and emailed to Ms. Mashitisho by 6:30 p.m. tonight. Thank you.
The court pleases, my lady.
As the court pleases.
Colleagues, can I